Well, just how does a judge make a decision on punishment in a criminal court case? With me is a criminal lawyer, Steve Bonnar QC. Steve, in many criminal cases, we tend to see, hear and read a post-judgment analysis from the media, particularly if it doesn't agree with the verdict. Now, it's not unexpected. They're the fourth estate, after all. They serve the public interest, and a big part of their work is, well, gauging the public sentiment, isn't it?
Well, you're right. They play a significant role as the eyes and ears of the community in relation to what's going on in our courts. And to some extent, they may reflect the views of the community. However, in my view, the media and we as lawyers also have a role to try to fully inform the community and educate the general public as to many of the reasons and policies which may lay behind some of the decisions of the courts.
So, just how does a district court judge determine the severity of a sentence?
When it comes to sentencing, a judge has to balance many different factors, and those factors are set out in our Sentencing Act and also in cases which have come before the courts on previous occasions, particularly those that have been determined by the higher courts. And a number of those factors in any particular case may be competing. For example, the judge may have to balance the legal principle that he or she should impose the least restrictive sentence which is appropriate in the circumstances, with another recognised sentencing principle, which is that they need the sentence should denounce the conduct and deter others. Now, it can be a very difficult exercise to balance those competing factors, and it's perhaps not surprising that judges sometimes say that sentencing is one of the hardest parts of their job.
Absolutely. So a lot to take into account, quite a few limitations to work with. Could a judge use his or her own discretion and perhaps say, look, despite the recommended guidelines for a first-time offender being no prison time, I've decided to use my own discretion and send this man or woman to prison, as it sends a stronger message to society?
Well, a judge is exercising a discretion when it comes to sentencing, but it's not an unlimited discretion. As I've said, a judge has to follow the law and has to follow the guidance that particularly the higher courts may have set out in previous cases. And it's important that our system has checks and balances. So if a judge gets it wrong, then either the defence or the prosecution have the right to appeal, and a higher court will look at the particular sentence.
Okay, so I'm a lawyer, I'm acting in the best interest of my client. What sort of strategy is generally taken on when defending someone who has already admitted their guilt, knowing that the client will obviously be punished, but they've admitted their guilt? What sort of strategy do you do?
Well, a defence lawyer, when it comes to sentencing, speaks on behalf of their client, and the defence counsel's role is to say everything that can appropriately and properly be said for their client in an effort to persuade the judge to impose the least restrictive appropriate sentence. But all lawyers, whether prosecution or defence lawyers, have duties as officers of the court, and no lawyer can mislead the court or misrepresent the facts. Both prosecution and defence lawyers have a duty to assist the court to take into account all relevant factors and to attempt to come to a just and fair decision.
Criminal lawyer Steve Bonnar QC, thank you.
Thank you.